Doing the Jesus Gozik? Does he, Isaac, 24W835-467?
All right. Court is officially in session. And notice how the defense attorney immediately clarifies is just standing in for the real lawyer. That's already a tricky position, because judges don't love it when substitutes walk in without the full background. It can change a whole energy in the courtroom.
Review on behalf of Mr. Geisig. I'm standing in for his attorney of record, David Burks, with his permission. Is that correct, sir?
Yes, sir.
Please state your name.
Julie Gozik. All right. Counsel, he pled guilty. Let me just double check. I actually put no contest plea. There was an indication he couldn't remember anything. So he pled no contest. Charge was.
Now here's an important detail. Instead of pleading guilty, the defendant went with no contest plea. Quick legal breakdown. No, contest means he isn't admitting guilt, but also isn't fighting the charge. It's like saying, I won't argue, but don't make me say I did it. Judges often read between the lines on this one.
I believe he pled this to, it was not taken under 771. They pled to attempt larceny on this, attempt larceny. So it's 45 days. Did you have the opportunity to review the report with him? Are there any material additions, corrections, or deletions?
Your Honor, I did have the opportunity.
Can I ask a question? Were you the guy in front of me? Pled on this?
Yeah.
I know he usually wears his hair back. I've never seen it down. If that makes a difference. I don't know.
Okay. Go ahead. I'm sorry.
No, that's okay. I did have an opportunity to review and go over the report with him. I will say that it does probably standard procedure here that obviously the criminal history is not included. It says it's attached. I know Mr. Geiser, he just pled guilty to a Third Circuit probation. It's a, I believe, fraud case, and that was just last month when he pled guilty to that. I'm sorry, I said probation, to a crime. He was sentenced to 2 years probation. He will be reporting out of Lincoln Park. I just wanted to advise you for that.
What case was that?
It was our Third Circuit court, and I think he said he was, I don't know if he pled guilty or was sentenced on February 21st. Sentenced on February 21st.
Did you catch that? The judge is tying this case back to a different conviction just last month. This is a big deal. Judges absolutely factor in your track record. If you're stacking up cases like trading cards, they're going to be a lot less sympathetic.
Yeah, that's all from the 9th September 23-24 incident, though.
Sorry.
Right?
I mean,
Did you go get fingerprinted last time?
Yeah. Well, I got things more like this.
Right. I'm sorry. Go ahead.
no, no, it's okay. So there are no corrections or deletions or omissions to be made on the report.
Anything you would like to say on his behalf?
Well, obviously, it has some significant transgressions, but I will state he is young. He has recently obtained a full-time job. Will be starting that job next week. I'm hopeful that this recent interaction with the court, plural, will help get him on the right track. He is also living with his mother, and she is present in the court.
Just trouble. You're the guy that was in front of me?
Yeah.
With Mr. Burgess last time?
Yeah.
Yes.
No, that's okay. I just looked a lot different to me.
Yeah, I can usually keep my
What? Remember what we talked about last time? What did we talk about? Arguing with your lawyer. Well, let me let you know what.
Okay.
Oh, here's where the tension spikes. The judge basically calls out the defense strategy, claiming the defendant doesn't remember. In court, that's dangerous ground. Why? Because either you're lying or you're admitting being such a habitual offender that it all blurs together. Neither plays well in front of a judge.
Burgess was insisting on a no contest on the basis that he lacked. There was the allegation. Let me rephrase that. There was a denial of him being under the influence of alcohol or drugs. First, they came in with a 771.1, which is not a very good judge if I take that with the guy or and see my vehicle. I don't care if it's under height or not. And then other felonies back in September. He's trying to tell me your client here, which I'm not excited about, that he didn't remember. Now, anybody listening to the conversation that has gotten past 8th grade would recognize there's only one way. He's either lying to me about not being able to recall. Because he wasn't under the influence of alcohol or drugs, and this didn't happen back in 1986. It happened 4 months ago. Or he breaks into cars all the time. Maybe he breaks into 19 cars a week. I don't know. Now, here's the good news, guys. I'm not arrogant enough to make up my own rules. I'm not arrogant enough to do that. I'm not going to listen to lawyers either tell me somebody doesn't remember. I mean, that could be like your client telling you it's 87 degrees out right now, and you're not questioning. And then you coming in here and telling me it's 87 degrees out, Judge. So that was the issue. Their issue is I'm not going to hold this against you because if you weren't telling me the truth, if you truly can't remember, you are on an escapade of stealing and breaking into cars unlike anybody. You understand what I'm telling you? Now the good news is I'm gonna assume you never broke into another car. You weren't convicted of anything else other than these things on your record. But I just get the feeling, and had the feeling not particularly, that you think this is some kind of a joke. Well, listen.
Whoa, did you hear that? The judge is not holding back. He flat out tells the defendant, "Do I look like the kind of guy that's going to sit here while you lie to me?" This is court and reality TV at its finest. A mix of frustration, sarcasm, and absolute authority.
Do I look like the kind of guy that's going to stand here idly by while somebody is telling me a lie and not call them out? This isn't a bar. We're not talking about fish stories here. Whether the salmon was 19 inches, 2 inches, or 8 feet and 7 inches. So if you truly couldn't remember, you're going to end up, and I was the one, right? What did I tell you about going to check out Department of Corrections? Pardon? It's not going to take you till 2030. That's what I said that day, didn't I? It's not going to take that long. You'll be there before that. If you have such little respect for the system and judges that you think you can come in here, tell me you don't remember something 4 months ago but weren't under the influence, you'll be there in 15 minutes. So first, and he's right, first the argument with Mr. Burgess was, Judge, those were under, I don't care if they're under HIDA. I'm not going to take 19 cases under a deferral statute or under 771, particularly when they're of the same ilk, theft offenses. I'm not taking them under 771. If somebody doesn't like it, they can run against me 5 times. I've been here since 1995. So you're getting the brunt, and I'm not directing that to you, but I want him to understand your client. And you can tell Mr. Burgess how I feel about this.
Absolutely, I understand, Judge.
I hope you do. And it's too bad that you're the one here, because I'd had a lot more to say.
I feel a little bit like I was a lamb sent to slaughter because I was not told about any of this.
Well, because maybe some people think they can do all the time. And maybe there's some judges that are going to buy it. I don't know. I'm not.
I respect the court's opinion, though.
And here comes a hammer. 12-month probation with a mountain of conditions. Pay attention here. Judges often stack fines, probation fees, and mandatory programs. It's not just about punishment. It's about creating constant checkpoints to test whether the defendant can actually follow rules.
12 months probation. You cannot leave the state without the consent of the court, violate any law or your address is Washington County, the hotel, come down, you must notify probation. You actually report to that. How much you attend the positive strategies program? Positive strategies program with 8-week follow-up. No contact with Ronald Treadhome. You obtain and maintain employment, provide proof. I don't know why you're not working. You're not disabled, right?
No, I just got a job.
Well, you weren't working for 2 years, though. Yeah. $100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4. Probation fees are $240 for 565. Screening fees 60 for 625. Restitution is $200 for 825. I hate to make it this much, but I don't really have any choice. I'll go $50 in costs. So 100 fines, 50 costs, 75 victims' rights, $50 justice assessment. So fines and costs are $275, screening fees 60 for 335, probation fees are $240 for 575, restitution of $200 for 775, $140 in court work program fees. You're going to serve 4 days on the court work program. Okay? $915. All these fees are pretty much mandatory here. $915. If you violate the condition, could be revoked, be incarcerated for 45 days. You may be eligible for early discharge. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? I hope you're listening to what I'm telling you.
Right.
Counsel, nice to have you here. Okay. Can he pay all of this today? How much can you pay today? Because you haven't been working. I don't know. They only give us one of these things. I don't like the path you're taking. $30 a week you pay, and I'll start that beginning March the 28th. More time. Tell them this is truthful counsel. All he has to do is call the court, go on Zoom on or before the due date. Come in here at 8:30 in the morning or before. On or before due date. If I have to give him extension fee 7 times, I'm fine with it. But he better not ignore me. You better straighten out your life.
Notice how the judge closes this out. Firm, but almost fatherly. You better straighten out your life. This is the classic blend of warning and opportunity. It's like the system saying, we'll give you a shot, but mess up again and it won't be this easy next time.
Good luck. Thank you.
Appreciate it.
Thank you.
Thank